Welcome to another episode of Disability Insurance Law TV. My name is Gregory Dell. I'm a disability insurance attorney with the law firm of attorneys Dell and Schaefer. Our law firm represents disability insurance claimants with applications, appeals, denials, and lawsuits of long-term disability claims. In today's episode, we are going to discuss independent medical exams and file reviews by disability insurance companies and things that you should expect if your disability insurance company has requested an independent medical exam. We're also going to discuss today biases of independent medical examining doctors. So here with me today is attorney Stephen Jessup.
Hello.
And attorney Cesar Gavidia. And one of the first things we're going to discuss is when you get one of these independent medical exam notices or letters from your disability carrier, does that mean that you have to go to this exam, or can you say, no, I don't really want to go? And Cesar, if you could talk about that.
Sure. It's not advisable to refuse to go to an independent medical examination in most cases. And the reason why is because oftentimes in most policies, attending an independent medical examination at the request of the insurance company is in fact a condition precedent, meaning that it's your obligation pursuant to those terms in that policy to go to the independent medical exam. Does it mean you have to go on that specific day that's being requested? If you have a doctor's appointment that day or you have something else going on, oftentimes the insurance companies are more than willing to accommodate you and schedule it on a day that you're available to go, or even provide you, in some cases, transportation there.
Okay, I think I know we've all read cases where a claimant decided they didn't want to go, and the case went to a lawsuit, and it didn't even make it to a jury or a judge because the judge said, I'm dismissing the case because you didn't show up for your independent medical exam.
Right.
So it's super important that a person does go to this independent medical exam. We're referring to them as independent medical exams, but they're really not independent medical exams. They're compulsory medical exams for the exact reason that you were just saying, that if you don't go, your case is going to get dismissed. So while we're going to use this term IME, independent medical exam, they're also known as CMEs, but I'm just referring to it for today's purposes as IME because that's what everybody refers to it as, and that's what the insurance company calls it, but it's by no means independent. So Steve, let me ask you this. When an insurance company sends this notice to the claimant and they say, we want to do an independent medical exam, what are they really looking for, and why are they asking for this exam?
Well, realistically, what they're going to be looking for, in my opinion, is some way to try to justify a denial of a claim. It may have been that they reviewed your medical records, they had one of their internal reviewers look at it, and there were some questions about, maybe we should have them go through an IME just to document it. Or it's a way to kind of counter what your own doctors are saying. So IMEs a lot of times can be the setup when they're going to either try to initially approve a claim for benefits, or as a case may be, as a grounds of in the near future trying to terminate the benefits themselves.
Okay. When these IME exams are requested, is it the same format for every single exam that a doctor is supposed to look for, or do the insurance companies ask the doctors to look for specific things?
You'll see sometimes, especially since I handle a lot of the ERISA appeals, once you get the claim file, you'll see where they will have a questionnaire sent to the independent review doctor. This is what we exactly want you to look at. We want you to compare it to the job duties, what they're saying, and this is where we want you to focus in on. Whereas other times, it may just be more of a general overall, they're going to do a full exam. In a case maybe like the functional capacity evaluation.
Okay. When the independent medical exam is done, does the doctors generally generate a report, correct?
Correct.
Is that report generally made available to clients, or is that report made available for a client's treating physician?
Usually for the treating physician. Most of the time when I request them, they say, it's not our policy to turn them over. In the event of litigation or in a denial on a group claim, you're entitled to get them. A lot of times they'll send them to the insured's treating physician for comment and review. And I've heard plenty of times, I'm sure you guys have too, contact their doctors if the doctor will release it to you.
Okay, and I think it's a good idea that we do in our practice too, is to try to ask the insurance company to have the independent medical exam report sent to the treating physicians before any claim decision is made, so that the treating physician can have the opportunity to comment on that report. Okay. Cesar, can a disability carrier deny benefits to a claimant if they've never had an independent medical exam done on a particular, on the claimant?
They certainly can. Just because an insurance company fails to request an independent medical examination of an insured person doesn't mean that they don't have grounds, under how they feel or how they've evaluated the claim to terminate the claim. It's usually done to further seek support for perhaps some findings they've already kind of felt are there. Many times these insurance companies have in-house physicians of their own that have certain findings based on the medical records, and then based from those findings they send the claim out to an independent medical doctor to look at what their own in-house physician is saying, what the claimant's own physicians are saying, and as they say, generate an independent report.
But if the insurance company is going to render an opinion that a claimant isn't disabled, how could they do that without ever examining the claimant?
Essentially what they'll do is they'll go to their own in-house doctors oftentimes, or some of their own in-house nurses, or sometimes send out the records that are already obtained by the claims people out to what they call independent peer review doctors, who just look at the notes, look at the records, and make a determination on whether there's any restrictions and limitations.
So just by looking at basically paper, they can tell whether or not a person's able to work or not?
Yeah, without ever examining the claimant, they'll essentially look at the paperwork, the records, and say that they could do their job.
All right, let's talk a little bit about the bias of these particular so-called independent medical examiners. I think that we've seen through our cases of litigation, through the ERISA appeals and information that we've obtained, and through seeing hundreds of disability cases, that these doctors are really not independent doctors. They're doctors who are paid to say whatever the disability insurance company wants them to say. So in anticipation of today, I did some research of cases that we had, as well as other cases that have been around the country. And I came across some stuff that you guys will probably find interesting. For example, there was a doctor who was trained at Harvard. His name's actually, he's a psychiatrist. His name's Dr. Stephen Gerson. And during a 4-year period, he was paid over $900,000 for solely conducting independent medical exams for insurance companies. So, and that was only a portion of his income, but that's $900,000. Of that, in 2006, $250,000 of that money was paid to him from Prudential Insurance Company. Another doctor, who in a federal case, a Dr. Amy Hopkins, was paid $493,832 over a 3-year period just to do insurance paper reviews, these independent medical reviews and paper reviews for the insurance company. So in one case regarding this Dr. Hopkins, the court specifically said that Dr. Hopkins would use a pick and choose approach that ignored evidence and completely mischaracterized a treating physician's notes in order to deny a claim. So, the companies do this and tend to go back to the same doctors, but they can't necessarily pull the wool over the judge's eyes or over a jury's eyes. So, one of the things we always try to do in our cases is get this information and get it to the courts. Because if you can't get it, then you're never able to expose the bias of this company. I know in a case we just handled actually out of Hawaii, we got evidence to show that the one doctor got paid just in 1 year $165,000 from Prudential Insurance Company. And then when we looked him up even further, we saw that he had several years in a row of getting over $100,000 in payments. So you can find out all of these things through a discovery process, through reaching out to other reading other cases around the country and trying to find this information, which can be very valuable.